Good day, everyone. My name is Jade Claire J. Downing from BSHM 3A, and I'm going to discuss about the labor law on Chapter 13. So, for the learning objectives, enumerate the classifications of employees, their benefits, privileges, and policies affecting them. Identify some best practices in handling human resources in tourism establishments. Identify the procedures in handling sexual harassment in a workplace. Explain the rights of workers employed in tourism establishments. For the topic outline, constitutional provisions on labor, classifications of employees, casual employees, seasonal employees, project employees, probationary employees, employees for a fixed term, overseas Filipino workers, special workers, benefits, privileges, policies affecting employees, death benefits, health benefits, drug testing, retirement, uniform policies, SSS, PhilHealth, employees' compensations commission, and pag-ibig, termination of employment, laws against discrimination, employment of women, sexual harassment in the workplace, best labor practices in tourism establishments. The tourism industry, with its labor-intensive nature, is prone to many labor issues. Hence, labor law plays a vital role in the efficient operation of the various business enterprises related to tourism. This chapter deals with important provisions governing labor laws as well as the benefits, privileges, and policies affecting employees. Constitutional provisions on labor. The law. Section 3. The state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, humane conditions of work, and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. The Constitution provides full protection to labor, ensuring the rights of all workers, including those overseas and in both organized and unorganized sectors, to fair employment, self-organization, collective bargaining, and a living wage. It promotes industrial peace through shared responsibility between workers and employers, preferring voluntary dispute resolution and regulating labor-employer relations to ensure both just labor compensation and fair business returns. Special provisions also protect working women and empower people's organizations to participate in national decision-making processes. Classification of employees. Employees of a company may be classified as follows: regular employees, casual employees, seasonal employees, project employees, probationary employees, employees for a fixed term, overseas Filipino workers, special workers like apprentices, learners, and handicapped workers. So for the regular employees, the employees who are deemed regular are those who have been engaged to perform activities which are usually necessary or desirable in the usual trade or business of the employer, and those casual employees who have rendered at least 1 year of service, whether such service is continuous or broken, with respect to the activity in which they are employed. An employee who is allowed to work after a probationary period, workers supplied by a labor-only contractor to the principal shall be considered regular employees of the latter. Casual employees. Casual employees are those whose employment is neither regular, project, nor seasonal, or defined under Article 280 of the Labor Code. There is casual employment where an employee is engaged to perform a job, work, or service which is merely incidental to the business of the employer, and such job, work, or services for a definite period made known to the employee at the time of engagement, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or not, shall be considered a regular employee with respect to this activity in which he is employed, and his employment shall continue while such activity exists. Seasonal employees. Seasonal employees are those whose work or services are seasonal in nature and the employment is for the duration of the season. Regular seasonal employees are those called to work from time to time. The nature of their relationship with the employer is such that during off-season they are temporarily laid off, but during summer season they are re-employed, or when their services may be needed. They are not, strictly speaking, separated from the service, but are merely considered as on leave of absence without pay until they are re-employed. Their employment relationship is never severed, but only suspended. As such, those employees can be considered as in the regular employment of the employer. In effect, these seasonal regular employees enjoy security of tenure and cannot be dismissed without just cause. Project employees. A project employee is one whose employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or services to be performed is seasonal in nature and the employment is for the duration of the season. The principal test for determining whether an employee is a project employee or a regular employee is whether the project employee was assigned to carry out a specific project or undertaking, the duration and scope of which were specified at the time the employee was engaged for that project. Failure of the employer to file determination reports after every project completion with the nearest public employment office is an indication that an employee was not and is not a project employee. Probationary employees. A probationary employee is one of who is on trial by an employer, during which the employer determines whether or not he is qualified for permanent employment. Probationary employment shall not exceed 6 months from the date the employee started working. In all cases of probationary employment, the employer shall make known to the employee the standards under which he will qualify as a regular employee at the time of his engagement. Where no standards are made known to the employee at the time, he shall be deemed a regular employee. Employees for a fixed term. Employees on a fixed term contracts are those whose employment is agreed upon for a specific period, with both parties voluntarily consenting to the terms without pressure or coercion. The contract is valid as long as it does not circumvent security of tenure laws, and the agreement must be entered into fairly without exploitation or unequal power dynamics. Employers and employees must ensure that their agreement is made on equal terms, free from any undue influence or pressure. Overseas Filipino workers, also referred as a migrant worker. Overseas Filipino worker refers to a person who is to be engaged, is engaged, or has been engaged on a remunerated activity in a state of which he or she is not a legal resident. A person to be engaged in a remunerated activity refers to an applicant worker who has been promised or assured employment overseas and acting on such promise or assurance sustains damage or injury. The law which governs overseas employment is Republic Act 8042, or the Migrant Workers of Overseas Filipinos Act of 1995. Special workers. Apprentices. An apprentice is someone undergoing on-the-job and theoretical training for a recognized occupation under a formal written agreement with an employer or accredited organization. The apprenticeship period must not exceed 6 months and covers trades that require over 3 months of practical training. Learners. Learners are individuals hired to train in semi-skilled jobs that are not classified as apprenticeable and can be learned through short-term practical training, limited to 3 months. So they are employed when experienced workers are unavailable and their employment does not harm labor standards or create unfair competition. Handicapped workers. Handicapped workers have reduced earning capacity due to age, physical, mental, or sensory impairment. According to RA 7277, they are entitled to equal employment terms, including compensations, benefits, and privileges as their able-bodied counterparts. Benefits, privileges, policies affecting employees. So first is minimum wage. By virtue of Republic Act number 6727, Wage Rationalization Act, the determination of minimum wage rates are now within the function of the regional tripartite and productivity board. The concept of minimum wage means more than setting a floor wage to upgrade existing wage. Minimum wages underlies the effort of the state to promote productivity improvement and gains sharing measures to ensure a decent standard of living for the workers and their families, to affirm labor as a primary social economic force. Collective bargaining. Collective bargaining involves negotiations between the employer and employees represented by a labor union to reach agreements on wages, working conditions, and other employment matters, which are formalized in a collective bargaining agreement. So this process requires majority representation, proof of such representation, and a formal demand to bargain, with negotiations starting within 12 months of certification of the bargaining agent. Failure to negotiate in good faith or violating the CBA's economic provisions constitutes unfair labor practice, and once a CBA is ratified by the majority of the bargaining unit, it must be registered within 30 days and remains effective for 3 years, with the representation aspect lasting 5 years. Labor Management Council. A Labor Management Council is a communication platform promoted by the Department of Labor and Employment, allowing employees unionize or not to raise grievances with their employer, even without a collective bargaining agreement. It serves as a venue for both management and employees to discuss concerns and resolve disputes, aiming to promote industrial peace. For the LMC to be credible and effective, employee representatives must be freely elected by the workers, not appointed by management. Maternity and paternity leaves. Maternity leave under RA 8282 entitles eligible female SSS members to 60 or 78 days of paid leave, depending on the type of delivery, provided by they meet contribution requirements and notify their employer and the SSS. Employers advance the payment and are later reimbursed. Paternity leave under RA 8187 grants married male employees 7 days of paid leave for the first 4 deliveries or miscarriages of their legitimate cohabiting spouse, given certain conditions are met. Solely parent under RA 8972 are entitled to an additional 7 days of parental leave annually if they have been employed for at least 1 year. Union rights, strikes, and lockouts. A legitimate labor organization has the legal personality to represent its members and must be certified as the exclusive bargaining agent to engage in collective bargaining. Strikes and lockouts is a refusal to provide work by employers can also be conducted legally in cases of collective bargaining that locked or unfair labor practices and must follow strict procedures including notice, cooling off periods, strike voting, and reporting to the NCMB. Unfair labor practices violates workers' rights to self-organization and collective bargaining, disrupt industrial peace, and harm healthy labor management niche relations. Service charges. Service charges apply to establishments like hotels, restaurants, and similar businesses, including certain government-owned entities. Of the total service charges collected, 85% must be equally distributed among covered employees, while 15% is allocated for management use, such as covering losses or rewarding managerial staff. Employment contracts. An employment contract is a legally binding agreement where an employee commits to work for an employer in exchange for compensation and is governed by the labor code, civil code, and other relevant laws. While parties are free to agree on terms, these must align with the legal and moral standards, and employment contracts are reviewed with public interest, favoring laborers' welfare and social justice. For clarity and protection, especially for probationary, project-based, or fixed-term workers, employment contracts should be written, clearly outlining duties, expectations, and company policies such as codes of conduct, job descriptions, and standard procedures. Death benefits. Under the Social Security law, if a member has paid at least 36 monthly contributions before death, their primary beneficiaries receive a monthly pension or a lump sum is given to secondary beneficiaries if no primary one exists. So if the required contributions are not met, a lump sum based on the number of contributions or 12 times the monthly pension, whichever is higher, is granted, along with a 12,000 pesos funeral grant. For work-related deaths, additional benefits are provided through the Employees Compensation Fund, including a monthly pension with a 10% increase per dependent up to 5 and a 10,000 pesos funeral benefit. Health benefits. A member who has paid at least 3 monthly contributions in the 12-month period. This includes sickness, medical, and hospitalization benefits. Under the Social Security, immediately preceding the semester of sickness or injury and is confined more than 3 days in a hospital or elsewhere with the approval of the SSS, shall be paid a daily sickness benefit equivalent to 90% of his average daily salary credit. In case of work-related sickness, the covered employee will be entitled to medical services, appliances, and supplies, in addition to the benefits under the SSS law. Drug testing. Under Republic Act Number 9165, also known as the Comprehensive Dangerous Drugs Act of 2002, drug testing must be conducted by government forensic laboratories or accredited drug testing centers to ensure the accuracy of results. Employers are required to implement company policies on a random drug testing to minimize workplace risk, and employees may be randomly tested. Employees who test positive for drug use may face administrative action, including suspension or termination in accordance with the Article 282 of the Labor Code. Retirement. Under Republic Act Number 7641, the new retirement law, employees can retire upon reaching their retirement age set in their collective bargaining agreement or employment contract. If no retirement plan is in place, employees aged 60 to 65 who has served at least 5 years in the company are entitled to retirement pay equivalent to at least 12 months' salary for each year of service, with fractions of 6 months considered as a full year. The retirement age is set at 65, which is the compulsory retirement age. Uniform policies. Some tourism establishments, which include but not limited to restaurants, department stores, rest areas and gasoline stations, deluxe and first-class hotels, tourist inns, special interest resorts, apartments, motels, and those engaged in water transport services, require their employees and staff to be well-groomed and should wear clean and smart uniforms. Uniforms policies in these establishments are prerequisite requirements in order to be accredited by the Department of Tourism. SSS, PhilHealth, Employees Compensations Commission, and Pag-ibig. Employees in the private sector are covered by the SSS law, which provides social security benefits for risks like disability, sickness, maternity, old age, death, and income loss. So the PhilHealth administers the insurance program, offering benefits for inpatient and outpatient care, including medical services, surgeries, and prescription drugs. Additionally, Republic Act 77242 mandates mandatory Pag-ibig Fund membership for all employees covered by the SSS, offering benefits like housing loans, calamity loans, and provident saving programs. Termination of employment. Workers have the constitutional right to security of tenure and protection against unjust dismissal, with termination allowed only for just and authorized causes under the Labor Code. The standards of due process for termination require a written notice, a hearing or conference for the employee to explain their side, a final written notice of termination after considering all circumstances. For authorized causes, due to process is satisfied with a written notice served at least 30 days before termination, while no prior notice is required for contract completion of probationary employment termination. Laws against discrimination. Laws against labor discrimination in the Philippines include Republic Act number 7277, the Magna Carta for Disabled Persons, which prohibits discriminations based on disability, such as unequal pay, promotions, or termination due to disability. Republic Act number 6725 strengthens the prohibition against gender-based discrimination, particularly in terms of unequal compensation and opportunities for women. Presidential Decree 966 declares violations of the International Convention on the Elimination of All Forms of Racial Discrimination as criminal offenses, with penalties for those found guilty. Employment of women. The state protects working women by ensuring safe and helpful working conditions, considering their maternal functions, and providing facilities to enhance their welfare and potential. The Labor Code prohibits the employment of women in commercial undertakings between midnight and 6 a.m. and requires employees to provide necessary facilities such as seats, toilets, and nurseries for women employees. Additionally, it is unlawful for employees to discriminate against women based on marriage, pregnancy, or potential future pregnancies, including dismissals or refusal to hire them for such reasons. Sexual harassment in the workplace. Republic Act number 7877, also known as the Sexual Harassment Act of 1995, defines sexual harassment in the workplace as any unwanted demand for sexual favors made by a person with authority over another employee, regardless of whether the request is accepted. Sexual harassment includes situations where such demands are made a condition for employment, promotions, or other job benefits, or where refusal results in discriminations or an offensive work environment. Employees are obliged to prevent sexual harassment by establishing rules and procedures, and they may face administrative sanctions if they fail to address such issues. Best labor practices in tourism establishments. Best labor practices in tourism establishments include proactive HR departments, thorough employee orientation, and regular performance evaluations. Benefits such as merit-based pay increases, bonuses, and additional perks like meal allowances, health care, and training programs are provided, along with adherence to due process in termination disputes. Furthermore, employee welfare is enhanced through activities such as sports events, recreational activities, and the publications of company policies and ethics codes. So to end this chapter with this quote, you don't have to be great to start, but you have to start to be great by Zig Ziglar. This quote by Zig Ziglar means that while you don't need to be perfect or highly skilled when you begin something, taking that first step is essential for achieving greatness. So that's all, everyone, for my report. Thank you for watching, and once again, I'm Jade Claire G. Downing from BSHM 3A, and have a nice day.